All right, it is now 2:00. Are you all able to hear me? Just indicate with a simple thumbs up if you are. I am Judge Melanie Williams. This is the State Expedited Accusations calendar. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All participants, this proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means that any member of the public can log on this particular proceeding. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. Before we begin, we have an extensive calendar today. I would like to move through this as efficiently as possible. Will the defense be requesting any breakout rooms?
Good afternoon, Your Honor. We did request breakouts for the Spanish interpreter, but I do not see any on the line. And as far as
we in courtroom 3, we're ready for the breakout session, and then we can start in courtroom number 2, Judge. Thank you.
All right, so other than Spanish interpretation, that was the only requested breakout room?
For Ms. Gant, Your Honor, Ms. Wright may want to chime in as well.
Ms. Wright, are you requesting? I want to do the breakouts first. Are there any breakout, are we requesting breakouts other than the Spanish interpretation?
Your Honor, I will not be requesting a breakout room. I speak Spanish and I spoke to my client. Of course, we'll need an interpreter for the hearing itself, but I will not need to speak to my client in a breakout room.
Is the interpreter present on the line?
I don't think we were able to get a Spanish interpreter today.
All right, so hearing that we do not have a Spanish interpreter, Ms. Gant, were you able to speak to you? Oh, Ms. McLeod has just chatted that she needed a Spanish interpreter as well. So I believe we'll have to reset those positions to Monday if Ms. Gant and Ms. McLeod were not able to speak to their clients. Is that correct?
That is correct for position 2, Your Honor.
Okay, so position 2 will be reset Monday for interpretation. Ms. McLeod, who was your client?
Hold on.
Just a moment, Your Honor.
All right. And also, are there any medical resets at the jail?
No, Judge.
Okay, thank you.
So I have all the interpreter cases in courtroom number 3, so they all will be reset until Monday.
Except Ms. Wright. Ms. Wright, you're able to do that case, correct?
Yes, Your Honor.
All right, we're gonna do Ms. Wright's case first. Who do you represent, Ms. Wright?
It's going to be Mr. Pablos Valladares.
Okay, and if you could help me, we did not have a calendar ahead of time. If you could tell me what number that is?
Position number.
Position number what?
I'm sorry, one moment, Judge.
21 for Ms. Wright's.
Yes, 21, position 21.
21, Pablo Valladares. All right. Mr. Valladares, your case number is 22 CR 004571E. And you're charged with possession and use of a drug-related object and loitering and prowling. Ms. Wright, I know that you are not an official interpreter, but would you be willing to interpret that to your client at this time?
So, Your Honor, I will be completely honest with you. I have tried to do that in the past. And I have been told by other judges in different jurisdictions that that is not.
It's not, but it's not ideal. It's not perfect. And I know you're not an interpreter, but if we don't do that, there's no way for us to take his position today. So
I will do my best. I will do my
what?
best to interpret for him.
Okay, you know what? I'm concerned that that's not going to be adequate, because then we're going to have to reset all 3 positions till Monday if we don't have interpretation. I don't see another way around that, especially in light of the challenges. So courtroom 3, we're going to have to reset all 3 positions till Monday SCA calendar.
I'm sorry about that, Your Honor.
No, go ahead.
Position number 1 just stated to me that he speaks English. He doesn't need an interpreter. But that's not what it said earlier.
All right, who represents position 1? Miss Gant, you represent position 1?
No, Your Honor, that is a conflict attorney McClaw.
Oh, Ms. McLeod, you represent position one. Have you had the opportunity to speak to your client?
No, Your Honor, I haven't had a chance to speak with him yet. I was
Okay.
told by the jail that I would have to wait until they got the Spanish interpreter.
Right,
So
now
I
I'm
was
hearing
not
that
able
he
to
speaks
speak with
English.
him.
Could courtroom 3 and Ms. McLeod be put to a breakout room? And Ms. McLeod, if you're able to speak with your client and understand what he's saying, we will go forward today. If not,
That would be fine if I can
if
get a
not,
chance
he'll be
to speak with
reset
him.
Monday.
Yes.
All right, Mr. Jordan, bear with us. Mr. Jordan, if you would put them into a breakout and we'll go back to courtroom 2.
And Your Honor, the state did not receive a copy of the calendar. We have a list of,
Okay.
we have the list of defendants that we received this morning, but we don't, so if it's referred to, and I'm prepared to go forward without one, I would like one, but
You should have it in your email now, Mr. Patrick, and it is good to see you. It's been quite some time since you've been before me. But if you check your email, I believe you should have a calendar now. It arrived 2 minutes before court began. And if not, perhaps one of your colleagues could send it over to you.
perfect.
I'll send it to them, sir.
It
They were
dinged.
probably not on the original list.
It dinged as right as you were speaking.
Okay, so yeah, that's when we all got it, Mr. Patrick. All right, we're off to a great start here today. All right, who do I have at courtroom 2? And if you don't mind telling me the position as well as the name.
Position number 3, Britain.
All right, good afternoon, Mr. Britton. Your case number is 22 CR 0045552G, in which you're charged with discharge of a firearm near a public street and reckless conduct with the offense date of July the 14th. Do you understand your constitutional rights that I just explained previously?
Yes, ma'am.
All right, who do I have from pretrial services?
Nikki
I think
Roberts.
Ms. Roberts, can you please give me his history?
I'm only showing one prior arrest from 2020 for entering auto, and that case is dead docketed. He's recommended for pretrial.
All right, thank you. Whose case is this, for the state?
It's mine, Your Honor.
All right, Mr. Patrick, again, good to see you. Been quite some time. Welcome back. If you would please give me the state's recommendation.
Yes, Your Honor. As to count 1, discharging a firearm near a public highway, the state is recommending a $5,000 good bond. As to count 2, reckless conduct, discharging the weapon is the underlying act. The state is recommending a $10,000 good bond. Your Honor, the state would show that the firearm was discharged inside of a residence. The bullet ended up in a wall. The residence was occupied by the defendant's mother at the time. Though you will hear evidence of a negligent discharge, not intentional discharge from the defense attorney in the case, the state believes this is a reasonable bond based on the facts as the state understands them at this time.
All right, and the state's recommendation was 5,000 on each. To be clear, Mr. Patrick?
5,000 count 1, 10,000 count 2 for the reckless conduct, a $15,000 good bond total.
Okay, thank you. And give me the factual basis very briefly, Mr. Patrick.
Yes, Your Honor. The defendant's mother was in an adjoining room. She heard the report of the weapon as it discharged, called officers. The officers arrived. The defendant had locked himself in his bedroom. When officers were able to gain entry to the room, initially there was no, he did not confront officers with the firearm, Judge. He denied possessing it. However, there was a bullet hole in the drywall. So the state is not aware how far the bullet penetrated, whether it penetrated both walls. However, it's a grave concern that the defendant's judgment was not sufficient to essentially, Judge, if you're going to play with a gun, make sure you don't discharge it. You shouldn't play with a gun anyway, but if you do, don't discharge it. And if you do, make sure no one else is in the house.
What were these special conditions requested as well, Mr. Patrick, or were there none requested?
No, Your Honor. The special conditions is that he not be allowed to possess any firearms or take any drugs or alcohol while out on bond. It is his residence, and based on his age, Judge, the state would not ask that he be put out of his home.
Okay, understood. Who represents Mr. Britton?
Good afternoon, Wanda Gant, Your Honor.
Good afternoon, Ms. Gant. Good to see you as well. Your recommendation, please.
Good afternoon, Your Honor. I will be requesting a signature bond on Mr. Britton's behalf. If he's eligible for a signature bond, I would ask for a very low bond. I spoke with his mother, Marquisha Britton. She is on the line. She informs me that she does not have the means to bond him out. Bond should not be punitive, and as the state concedes, he's only 19 years old. He does not have any prior convictions. Mr. Britton has been in the Atlanta, Georgia area his entire life. He has family here, therefore he has community ties. He completed high school. He is unemployed, Your Honor. We are denying the allegations. These are, at this point, just that, allegations. He is presumed innocent. I am requesting a signature bond, and if Your Honor determines that he is ineligible, then I would ask for a very low bond of no more than $2,000 total. That would be $1,000 for each charge. Thank you, Your Honor.
All right, thank you. At this time, the defendant is going to receive a split bond. On count one, he is going to receive, let me see, hold on one second. I'm really bad at math, 1 second. Of course, the special conditions that will apply is that he is to have no alcohol, drugs, or weapons as a condition of this split bond. He is going to receive a $10,000 signature bond through the jail for count one and a $2,000 surety bond for count two, for a total of a $12,000 split bond. He is to have no weapons, drugs, or alcohol. Is there anything further from either the state or the defense as it pertains to this bond?
Nothing from the state, Judge.
Nothing from the defense regarding the bond, but I also would like to inform the court too that I will be requesting a BHET based upon some information received from his mother, Your Honor.
All right. Is there anything special you'll need me to sign as part of that BHET, Ms. Gant? I don't believe so, but I wanted to verify that. All right, thank you. All right, best of luck to you, sir. Who do we have next?
Position number 12, listen more.
Okay. It's very difficult. All right, position 12.
Good morning, Your Honor.
Good morning. All right. Mr. Lissamore, your case number is 22 CR 00452. 45628, and which you're charged with battery against a pregnant female. Do you understand the constitutional rights that I just explained to you?
Yes, ma'am.
All right, Ms. Roberts.
He has 9 cycles. He has a last arrest was from February of 2021 for battery out of Clayton County. He does have a battery, family violence, and criminal trespass conviction from 2021. A battery conviction from 2020 and a criminal trespass conviction from 2022, and nothing further.
All right, thank you. Whose case is this for the state?
Alexis Guidry, Your Honor.
Oh, good to see you, Ms. Guidry. Your recommendation?
Yes, Your Honor, we are recommending for the battery against a person who is pregnant, a $8,000 surety bond, no further contact with Shanice, that's SHANIECE, Edwards, common spelling, a stay away from 3079 Sable Run Road in Atlanta, 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, we would tend to prove that on May 20th of 2022, at the location of 3079 Sable Run Road, the defendant and his daughter stayed with the victim, Shanice Edwards, for the night because he had nowhere to stay. Ms. Edwards went to sleep in her bedroom when she was awakened by the defendant attacking her. The defendant then took the victim's vehicle and then fled the scene. Ms. Edwards had visible injuries to the inside of her upper and lower inner lip. At the time of this incident, the victim was pregnant with the defendant's child. And the victim would also like to know that the defendant did at the time take 2 Xanax bars, so that is why we're asking for no alcohol, drugs, or weapons. Your Honor, we're concerned that the defendant is a risk of reoffending given that he has a battery family violence conviction. He has an open battery family violence case, as pretrial has stated, from February of 2021 out of Clayton. He has a simple battery family violence case that is also open in Clayton County from December of 2021. And it seems as if he has a robbery and pointing or aiming a weapon or pistol at another that is also open from DeKalb. Your Honor, we do not know who these victims are at the time because it is Saturday, so we are unable to ascertain that information. Given this information and these family violence batteries that are open and guilty charges that he has, we're concerned for the victim, and given that she was pregnant. So that's why we asked for those conditions and the stated bond.
All right, thank you. I'm gonna sound for Ms. Edwards at this time. If Ms. Edwards is on this Zoom conference and would like to make a statement, this is your opportunity to do so. All right, hearing none. Who represents this defendant?
It'll be me, Your Honor. I'm Anna
All
Wright.
right, Ms. Wright, please proceed.
Yes, Your Honor. I did get a chance to speak with Ms. Edwards today. I'm happy to give the court a phone number if you'd like. They are very much still together. He's the father of her child. She is heavily pregnant. She's due any minute. She's very upset about this warrant taken out on him. She had originally called the police because they'd had an argument that day, and he wanted to leave to cool off, and she did not want him to take her car keys to do so, but he wanted to leave to cool off. She blocked him, and in the scuffle she was hurt, but it was certainly not intentional. So when she called the police, it was in regards to her car, which he later returned and returned the car keys to her. They are still together. She does not want him in jail. She does not want him prosecuted for this charge. And she was not even told that there was going to be a warrant taken for the family violence charge. Again, she only called about the car keys on this. We are asking for a signature bond. My understanding is that he does have some kind of hold in a different county. So if he can get out of here and go straight to the other county so that he can resolve that case and be back together with Miss Edwards, that would be what she would want done with this case.
All right, I understand that. Ms. Wright, after we complete this case, we're gonna revisit the interpreter needed cases. And as a reminder to everyone, those who receive a surety bond today will be reset to the SAP calendar on July the 28th of 2022. Okay, thank you, Mr. Jordan. All right, at this time, the defendant is going to receive a $5,000 surety bond. He is to have no further contact with the victim, last name Edwards, and he must stay away from that location on Sable Run. He is to have no weapons, drugs, or alcohol as a condition of the surety bond. And again, he will be reset to the SAP calendar on July 28th, whereby the case will be revisited at that time. All right, anything further from either the state or the defense?
Nothing further.
All right, thank you. Going back to the case, Mr. Jordan says an NOD was filed. Okay, I see that case. It's not on the full sheet. Thank you. All right, Ms. Wright, would you perhaps like to speak with your client and ask him if he would like to waive his appearance today? Then I could set a bond and you could represent him at this hearing if you feel comfortable that he is able to understand your degree of Spanish. That might be one way that we could take care of his position, and then you could enter that formal waiver shortly hereafter. I'm sure the state will have some objections, but in light of the fact this is the weekend, I would like to handle his case if we could.
I'd be happy to do that, Your Honor.
All right, so before we do that, Ms. McLeod, were you able to speak to your client and was he able to understand you? You're mute. He speaks English.
Yes, Your Honor, he
Okay,
does.
very quick, very good. What we'll do is at court, can Ms. Wright be placed in a breakout with courtroom 3 and speak to her client to see if he would like to waive his appearance? Ms. Wright, please explain.
I'm sorry, Judge. I'm sorry, I apologize. But we have took those two defendants back to new intake.
Okay. Can Ms. Wright give him a call just to see if we can waive his appearance today? Is there a phone that could be just taken to him and we could keep going?
We can keep going, just give me a minute, we'll go back and get it.
Okay, he may not even want to waive his appearance, but I'm hoping to at least give him a bond. Who do we have at courtroom 3 now?
Position number 1, please.
Okay, thank you. All right, we have Mr. Jose Barjas Rangel. Is that your name, sir? All right, your case number is 22 CR 004550E, in which you're charged with criminal trespass, family violence with the offense date of July the 15th. Do you understand your constitutional rights? You do?
Yes.
Okay. All right, Ms. Roberts.
3 cycles. All of his cases were dismissed. His last arrest was July 3rd of this year for theft by taking. That case was also dismissed.
All right, thank you. Whose case is this for the state?
It is mine. Oh,
It's mine for the state, Judge.
Okay, thank you. Mr. Patrick, your recommendation.
Yes, Your Honor. The state is recommending a $10,000 good bond in this case with special condition that he possess no weapons, alcohol, or drugs while on bond, and that he stay away absolutely from 170 Creekmont Way in Roswell. Your Honor, the facts of this case are troubling. The defendant was awoken from a nap and saw that his window had been broken in his bedroom of the shared residence. He emerges from his room with a machete, asking who or how the window was broken. He was told that the window had been broken, and while he was returning to his room, he used the machete to break the window that is subject of this charge. Your Honor, though the case was dismissed, he has an arrest from 2015 from the Roswell Police Department for family violence, an act of family violence. Though that wouldn't be admissible at trial, you are certainly permitted to consider it for the purposes of bond. So the state would proffer that the defendant has a demonstrated history of acting violently and tumultuously. And in this instance, he emerged from his room with a machete, questioning how his window was broken, which is a disturbingly disproportional response. And therefore, the state would say that despite the fact that he resides at the residence, he should stay away and that he should have a $10,000 good bond. Your Honor, the state would point out that that means he would only be required to post $1,000 of actual money. So the state believes that these are generous terms and that any argument based on residency or work history, that those factors the court should weigh much more lightly than the other bond consideration factors, Judge.
All right, thank you, Mr. Patrick. Ms. McLeod?
yes, Your Honor. My client is 37 years old. He is gainfully employed, Your Honor, and the house in question is his house. The complaining witness, she's lived there as a tenant who he has been trying to evict because of COVID. She hadn't been paying and so on. She has a boyfriend who has come there and has been very disruptive. And my client believes that the boyfriend was the one who broke this window. Naturally, he's afraid of the boyfriend and he keeps a machete for protection. He did not use it against anyone. He emerged with a machete in his hand because the window was broken. Naturally, that would be a cause for concern to anyone, Your Honor. My client has a 4-year-old child. He has absolutely no criminal history. As the pretrial has said, any charges against him were all dismissed. There is no evidence that he has done anything criminal at all. And what he did was his window was broken. He emerged with a machete. I don't see any basis of saying that he is any threat to anyone. This woman has been living in this house for some time. And she can't say that there was anything else concerning my client, but her boyfriend came there, was threatening, and the window was broken. So naturally he had a concern. He didn't know if there had been an intruder or whatever. Everybody keeps something in their home to protect themselves in case they are attacked. There was nothing unreasonable about my client's behavior under the circumstances, Your Honor. I think he's a good candidate for a signature bond. The fact that he may have been arrested in 2015, 7 years ago, it is clear, even the prosecution said so, that this was dismissed. Therefore, he has nothing on his record, and there's nothing that the case that the state has shown which would suggest that he's any threat to anyone at all. And this is his home. To ask him to not to go back to his own home, it would be a bit much when all he did was came out of the machete because there was a broken window in his home. Thank you, Your Honor.
Thank you. At this time, the defendant is going to receive a $2,500 surety bond. He is to have no weapons, including the subject machete, drugs, or alcohol as a condition of that surety bond. Anything further from either the state or the defense?
No, Your Honor.
Nothing from the state, Judge.
All right. Best of luck to you, sir. Who do we have next?
Position 7, Mr. Holloway.
Position 7. All right. All right. All right, bear with me. All right, Mr. Holloway, your case number is 22 CR 004556F, in which you're charged with simple battery with the offense dated June the 25th. Do you understand your constitutional rights?
Yes, Your Honor.
All right, thank you, Ms. Roberts.
I'm only showing one prior arrest from 2008. The arrest was for DUI, and it was a conviction for reckless driving. And
thank you. All right, Mr. Patrick, this is your case as well?
It is, Judge.
All right.
Your Honor, the state in this case is recommending a $1,000 good bond and have no contact with James Shamblin, no weapons, alcohol, or drugs while out on bond. Your Honor, the state would show that the defendant pushed the victim into a swimming pool during a altercation.
All right, what was the name of the alleged victim?
James, traditional spelling, Shamblin, Shamblin.
All right, Mr. Shamblin, if you are present on the Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none, Ms. Gant.
Thank you, Your Honor. I'm requesting a signature bond on Mr. Holloway's behalf. As we heard from pretrial, this is his second arrest. The last arrest and conviction was 2008. It's for a driving offense. There are no convictions for violence. Mr. Holloway is 50 years old. He has been in the Atlanta, Georgia area since 2007. He has 2 children, ages 12 and 14. The 14-year-old lives with him and he pays child support for his 12-year-old child. Your Honor, Mr. Holloway completed high school. He has a doctorate degree in pharmacy. He was a university assistant professor. However, he is now on long-term disability. He denies the allegations, Your Honor, and we are unopposed to the no contact order as my client does not know the complaining witness, Mr. Shamblin. So in closing, Your Honor, a signature bond as he has recommended, and again, we're unopposed to the no contact order. Thank you.
At this time, Mr. Holloway is going to receive a $3,000 signature bond through pretrial services. He is to have no further contact with the alleged victim, last name Shamblin, and he is to have no weapons, drugs, or alcohol as a condition of that signature bond. He will be reset for the notice. Anything further from either the state or defense?
Nothing further from the defense, Your Honor. Thank you.
Nothing from the state, Judge.
All right, best of luck to you, sir. Who do we have next?
Position 13, McAfee.
All right. All right. Good afternoon, Mr. McAfee. Your case number is 22 CR 004563B, in which you're charged with 1 count of battery family violence with the offense date of June the 13th. Do you understand your constitutional rights?
Yes, ma'am.
All right. Thank you, Ms. Roberts.
he has 3 cycles. Last arrest, October of 2020 for burglary in the first degree out of Clayton County. That was a conviction. He does appear to be on probation for that case. The disposition date was May of 2021, 1 year confinement, 4 years probation. His other 2 arrests were both criminal trespass, both no disposition, and nothing.
Right. Thank you. Ms. Guidry.
Yes, Your Honor, we are recommending a $6,000 surety bond. No further contact with Melissa Charlotte, that's CHARLOT. A stay away from 2280 Campbellton Road, Southwest Atlanta, the entire complex. 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, we would tend to prove that on June 13th of 2022, the defendant hit the victim in the head with a glass bomb, threw a cell phone at her stomach, and punched her and slapped her. At the time, the victim was 17 weeks pregnant with the defendant's child. The victim had a knot on her head and complained of pain of her upper left arm, neck, and back. The parties do already have a child together, and at the time they did live together. We would like to state that when we find out more information about this glass bomb, that depending on the size, we will have this transferred to the DA's office as an aggravated assault. We're concerned for the safety of the victim, given that at the time she was 17 weeks pregnant, so we know that she's still pregnant. And he is a danger to the community, given that he does have a conviction for burglary in the 1st degree. However, as we stated, we are concerned for the victim's safety in this case, Your Honor. We have not had any contact with the victim, I believe because we didn't have a phone number for her given from the police officers. So with that, we would ask for the conditions as stated and the recommended bond.
All right, thank you. I'm going to sound for Ms. Charlotte first before I go to Ms. Wright. Ms. Charlotte, if you're present on this Zoom conference and you wish to be heard, this is your opportunity to speak. All right, hearing none, Ms. Wright.
Yes, Your Honor, I did speak with Melissa Charlotte. I do have a number for her. I spoke to her. She said she did not call the officers that day. Someone from the building where they lived together did. Nobody told her that there was going to be a warrant out for his arrest, that she's been calling she's been trying to contact the prosecutors about this, and she has not received any kind of callback. She is pregnant. They are still together. They do have 2 children together. She does want him back home. And she was actually arrested that day. She had a failure to appear, and they arrested her, and I think they took her to Clayton County. And at no point was she told about him being arrested. The officers could have easily asked for her phone number at that point, and I guess they didn't if Ms. Guidry doesn't have that information. We are asking, Your Honor, if there's going to be an order that it be a no violent contact order. Like I said, she was very upset. She does want contact with him.
All right, thank you. At this time, defendant's going to receive a $4,000 surety bond. He is to have no contact with the victim, last name Charlotte, and he is to stay away from the address on Campbellton Road. He will be reset to the SAP calendar on July the 28th, whereby contact and this bond can be revisited.
You're
all right.
Ordering no alcohol, drugs, or weapons.
Oh, and no alcohol, drugs, and weapons as a condition of that bond. All right, thank you. Best of luck to you, sir. Mr. Jordan, can Ms. Wright be placed in a breakout room with courtroom 3 so she can discuss whether or not her client would like to waive his appearance today? All right, who do we have next?
Next is position 8, Hunter.
Okay, position 8. All right, this is Christopher Hunter.
Correct.
Thank you. Mr. Hunter, your case is 22 CR 0045558C, in which you're charged with criminal trespass and stalking, a misdemeanor offense, with the offense date of September the 16th of 2021. Do you understand your constitutional rights?
Yes, Your Honor.
All right, Ms. Roberts.
He has 5 cycles. His last arrest was in 2017 for cruelty, aggravated assault, and false imprisonment. The cruelty and false imprisonment were both dismissed. The aggravated assault was amended to disorderly conduct, and that was a conviction in 2018. And then he had a theft by shoplifting conviction from 2009 and one probation violation for that theft by shoplifting from 2010. And nothing further.
All right, thank you. Whose case is this for the state?
Your Honor, that's my case.
All right, Mr. Patrick, please proceed.
Yes, Your Honor. The state is recommending a $15,000 surety bond in this case. Your Honor, the state recognizes that's higher than courts typically hear as our recommendation. However, and I apologize. Additionally, we're also requesting a stay away from 2305 Jamison Pass, Alpharetta, and an absolutely no contact with Tyrecia. That's spelled Tyricia, Miles, Myles. No alcohol, drugs, or weapons of any kind in his possession. Your Honor, you heard that he has an arrest history of kidnapping, albeit those charges were amended and he pled to a misdemeanor. That does not negate the underlying facts of that case. But here, Judge, the case before you today for consideration, Your Honor, the defendant had been instructed to not return to the residence. He returned to the residence, was chased off by a male occupant, and then text the named victim, Miss Miles, stating that they needed to talk. Your Honor, the defendant's record, which is absolutely capable for being considered by this court for bond, demonstrates that he doesn't make good choices when it comes to interacting with folks. Your Honor, essentially, your task is you're making a bet against yourself as to whether or not this defendant is likely to reoffend while out on probation or out on bond. Given the fact that he has a prior very, very serious offense for ag assault and kidnapping in his past, and that he has been arrested for stalking in this instance, Judge, the state would like to recommend no bond. I'm sure you're going to hear argument that $15,000 is tantamount to no bond. Your Honor, the state would point out that the word tantamount is nowhere in the statutory considerations for Your Honor. He is required to have a bond, but that is all. Therefore, the state is recommending a $15,000 bond in this case.
All right, thank you. Ms. Gant.
Thank you, Your Honor. Mr. Christopher Hunter is 32 years old. He has spent in the Atlanta, Georgia area his entire life. He is a proud father of a 7-year-old daughter. That daughter lives with him. He is the primary caretaker. We are unopposed to the stay away at the incident location. Mr. Hunter has a high school diploma. He also has 3 years of college at Georgia State, where he studied business. He is currently employed at vehicle wrapping. He has been in that position for the last 1 year. Your Honor, my client adamantly denies the allegations. He states that he has not seen Ms. Miles in over 2 years. Your Honor, I am requesting a signature bond on Mr. Hunter's behalf. He is recommended, as we heard from the from pretrial. He was convicted for a disorderly conduct charge, and actually for that conviction and plea suggests to me that the facts did not support an aggravated assault charge. Your Honor, this incident occurred in 2018. It's a different person. We do not have any convictions for violence. My client is presumed innocent. His FTA was in 2010. That is far too remote for this court to consider. He has community ties. Therefore, I am requesting, Your Honor, a signature bond. If Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000, and that would be $500 for each count. Thank you, Your Honor.
All right, I'm going to sound for the alleged victim, last name Miles. Ms. Miles, if you are present on this Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none, the defendant is going to receive a $4,000 surety bond, $2,000 on each charge. He is to stay away from that incident location on Jameson Pass, have absolutely no contact with Tyrecia Miles, and have no weapons, drugs, or alcohol as a condition of that surety bond. Is there anything further from either the state or the defense at this time?
Nothing from the state, Judge.
Nothing from the defense. Thank you, Your Honor.
All right, best of luck to you, sir. All right, back to courtroom 3. Ms. Ms. Wright? Ms. Wright, did you have an opportunity to see if your client would like to waive his appearance today?
Yes, Your Honor, and he did.
All right.
Would you like me to file a waiver?
Yes, please send that formal waiver to Mr. Jordan.
To
Are
Mr.
there any other positions that we can take that we will need to take at courtroom 3? We'll do that waive position last so that we don't hold the jail. Are there any other positions at courtroom 3 that we need to take?
Yes, Judge, I have position number 4.
All right. All right. Are you Jessica Bub?
Yes, ma'am.
All right. Your position number is 22 CR 004553J, and what's your charge with simple battery with the offense date of July the 15th of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. Thank you, Ms. Roberts.
Showing this being her first arrest.
All right. Thank you. And whose case for the state?
It's
Is it
my
you,
case,
Mr.
Judge.
Patrick?
Yes.
Yes, Mr. Patrick, please proceed.
Yes, Your Honor. The state is recommending a $1,500 good bond in this case, Judge. The state and to have no contact with the cross defendant Jasmine Torres. That's traditional spelling of Jasmine, and then Torres is Torres. Your Honor, the facts would show that this defendant pushed Ms. Torres with both hands during an altercation.
All right.
Between the two.
All right, thank you. Ms. Gant?
Thank you, Your Honor. I am requesting a signature bond. As we heard from pretrial, this is my client's first arrest. My client denies the allegations. The complaining witness was arrested in this matter as well, and placed my client in a headlock, Your Honor, and my client had a visible abrasion. Ms. Bub is 26 years old. She has been in the Atlanta, Georgia area her entire life. She is the leaseholder at the apartment. I am requesting that there not be a stay away put in place against my client. Ms. Bub informs me that she does not want to have any contact with the complaining witness, Ms. Torres. Therefore, we're asking for a one-time law enforcement escort so that Ms. Torres can get her belongings out of there. Ms. Bub completed college. She studied psychology. She is now self-employed. She works for Lyft and Uber. She's been doing this part-time for about 3 months. She does not really have the means to put much toward bond given her employment status at this time. And again, we are denying the allegation. She's not the primary aggressor, and I am requesting a signature bond, no stay away, and no contact. Thank you.
Thank you. At this time, the defendant is going to receive a $3,000 signature bond through pretrial services. She is to have no further contact with the cross defendant, last name Torres, and she is to have no weapons, drugs, or alcohol as a condition of that signature bond through pretrial. Is there anything further from either party?
Nothing from the state, Judge.
Nothing from the defense, Your Honor. Thank you.
All right. Who do we have next?
Position number 6, Harris, please.
All right.
Come on, Ms. On.
All right, good afternoon. Ms. Harris, your case is 22 CR 004555J, and what you're charged with simple assault, family violence, and criminal trespass, family violence with the offense date of July the 15th. Do you understand your constitutional rights?
Yes, ma'am.
All right, thank you. Ms. Roberts?
First arrest recommended with the cosigner.
All right, thank you. Mr. Patrick?
Yes, Your Honor. Your Honor, the state would actually be recommending a, sorry, I can't read my own note, would be recommending a $1,500 good bond for each offense. Your Honor, the state would show that the victim in this case is, and the defendant or mother-daughter. The facts of the case are that during an altercation over taking a picture of Miss Tavica, T-A-V-I-C-A Thomas, the defendant struck Miss Thomas on the left arm and then caused damage to the television. Your Honor, based the state understands that the I believe I saw the victim on the line, if she would like to address the court, Judge.
All right, and you're not requesting any special conditions other than that?
Oh,
1,500?
I apologize, Judge. The state is recommending no alcohol, drugs, or weapons while out on bond. And my understanding is that they live together, and the defendant is rather young, Judge. The state would be recommending no violent contact unless Ms. Thomas voices otherwise to the court.
All right, thank you. I'm going to sound for Ms. Thomas before I go to Ms. Gant. Ms. Thomas, if you would like to be heard, you'll need to turn on your camera. This is your opportunity to address the court.
Your Honor,
Yes.
I do apologize for interrupting. May I be heard before Ms. Thomas?
All right, Ms. Gant. I'm not sure why you're making that request, but that's fine. Go ahead.
Okay.
Your Honor, I hate to interrupt, but based on the defendants, the state reserves the right for counter argument.
I always give counter argument, Mr. Patrick. If I allow one person to cross the victim or the witness, I always give you a chance to respond. So no need to request that especially. Go ahead, Ms. Gant. I'm curious as to why you wanted to go before the victim, but go ahead.
Thank you, Your Honor. Ms. Harris is 17 years old. She has been in the Atlanta, Georgia area her entire life. She does not have any children. She has family in Atlanta, including her mother. Your Honor, we are unopposed to the no violent contact order. I did have the occasion to speak to Ms. Thomas. She informed me that she wants her daughter to come back home. She does not have anywhere else to go. Based upon some information that Ms. Thomas provided me, I will be entering a request for BHET evaluation. A little bit more about Ms. Harris. She dropped out of school when she was a freshman. She has been having some difficulties. Her father passed away, Your Honor. She does plan on returning to school, and her mother is taking steps to ensure that Ms. Harris gets some care for some of her issues, which are confidential. Ms. Harris is unemployed. She has never worked anywhere. She does not have the means to pay anything toward bond. Her mother doesn't have the means to pay much of anything toward bond, Your Honor. I am requesting a signature bond. Ms. Harris is recommended. She doesn't have any prior history. She denies the allegations. And again, we are unopposed to the no violent contact order. Thank you.
All right, thank you. Ms. Thomas, I'm going to hear from you, but before you speak, please raise your right hand. And please turn your camera on. Thank you. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, before you speak, what the court really is interested in, Ms. Thomas, is whether you wish to have your daughter return home and whether you wish to have contact with her. That is what the court is most concerned with at this time.
Yes, ma'am.
All right, and are you willing to serve as a co-signer for her? She will need a co-signer in order to be able to be released from Fulton County Jail.
Yes, ma'am.
All right. Is there any very limited other thing you would like to make the court aware of? I'm aware of some issues through Ms. Gant, and I would prefer if you did not say that on the public record.
No, ma'am. That's it. She pretty much said everything. Thank you so much.
All right. Thank you. Mr. Patrick, anything further? All right.
Nothing from the state, Judge.
All right. Ms. Gant, anything further?
Nothing further from the defense, Your Honor.
All right. At this time, the defendant's going to receive a $3,000 signature bond through pretrial services. She is to have no weapons, drugs, or alcohol as a condition of that. I'm going to recommend a BHET as well. Ms. Roberts, other than the name Tavikia Thomas, will you need other information for the co-signer?
Do not. Ms. Thomas, just make sure you come with a valid ID and a utility bill with the same address that's on your ID.
Okay,
right,
thanks.
Ms. Thomas, please bring those. All right. I believe that will conclude the case. Best of luck to you, Ms. Harris. Who do we have next?
Judge Williams, what's the
Yes.
breakdown of that? $3,000?
Oh, $1,500 each charge.
Thank you.
Thank you.
Candace, next, please.
I'm sorry, I couldn't hear.
1919.
Thank you. There is a loud alert going off. I could not hear. All right. Is this Marquita Terry? All right, Ms. Terry, your case is 22 CR 4569Y, in which you're charged with battery family violence with the offense date of July the 15th. Do you understand your constitutional rights?
Your Honor, can we ensure that they can hear, given that there is?
That's why I'm asking those questions. That gives me the opportunity. Can you hear me, Ms. Terry?
So can we just
Okay.
step out?
Yes, can we go to courtroom 2 while courtroom 3 works that out?
Oh, yeah, Judge.
Oh, it's the whole jail. Well, that's quite unfortunate. While that's happening, let's go to the waived position then. Let's do that so we can keep moving. Ms. Wright, your client again, please remind me of the position that was waived.
I think it's position 22.
Okay.
Pablos Valladares.
21.
All right.
21.
20. All right. It's very difficult toggling back and forth. Bear with me. The waived position is Pablos Valladares. I'm not sure I'm saying that correctly. Case number 22 CR 004571E. Ms. Wright has certified that she was able to speak to her client. He understood her and waived his appearance today. He's charged with possession and use of drug-related objects and loitering and prowling with the offense date of July the 15th. Ms. Roberts, can I have that history?
No criminal history.
No history? All right. Ms. Guidry.
Yes, Your Honor. We're recommending $1,000 surety bond on each count, a stay away from 340 South Atlanta Street. That is the Atlanta Street Baptist Church. And no alcohol, drugs, or weapons. Your Honor, yesterday, the defendant was at the address. Officers were doing a premise check in the area due to the defendant walking around the neighborhood, peeking in windows around 11 p.m. They eventually found the defendant sitting at Atlanta Street Baptist Church at 1 a.m. They asked the defendant why he was there, and he stated that he was waiting on his nephew, but he could not provide a number for the nephew nor where he lived. The defendant did give permission for the officers to search, and they found a glass bulb smoking device with methamphetamine residue in his right side shirt pocket. Your Honor, we're concerned for the danger to the community, given that the defendant was seen peeking in windows around that area and in that neighborhood. So that's why we're asking for a surety bond of $1,000 each with the conditions.
All right, thank you. Ms. Wright?
Yes, Your Honor. We're asking for a signature bond for Mr. Valladares. He is not a violent person. He has no history of violence or anything whatsoever. Even in this case, he has not seen hurting or trying to hurt anyone. He was sitting outside of a church when the officers found him. He does not speak any English whatsoever. So whether he gave permission for the officers to search or not is highly suspect to me at this point. He does have some issues in terms of being residentially challenged, but he let me know that he would be living with his parents who live in Atlanta. And he has lived here for 22 years, Your Honor. He does have a job. He is a driver for a company, but I was having a hard time hearing him, so I'm not really sure what the name of the company is. Again, Your Honor, my understanding is that pretrial is also recommending a signature bond, and that's what we're asking for.
All right, at this time, the defendant will receive a $2,000 signature bond through the jail, $1,000 from each charge, and he has to stay away from that church. If you can make that clear to him, Ms. Wright, upon speaking with him later. He is further to have no weapons, drugs, or alcohol as a condition of that signature bond.
Thank you, Your Honor.
All right. Are we still having an alarm at the jail?
Yes, it's still going on. I'm trying to speed this calendar up because it's been going on all day.
Are there any dynamic solutions that anyone perhaps might have?
No, I'm sorry, Judge.
I'm very sorry too. I hate, this is a long calendar and I was doing my best to move it as it was a Saturday. We'll be on hold. And is there, and there are no other waive positions, are there? No.
No.
All right, well. At the jail, as soon as it stops, I'll be ready to start and we'll go back to what position will we go to? We'll be back at 19.
We'll go back to position number 19.
Okay. Well, this has been quite a afternoon. And there's no one in medical or any other place we could take.
Judge, if the state could inquire, does the device on which the jail projects the image have the Spanish simulcast function, like for where it shows words on the screen that the inmate could read as we talk? The simulcast I think is what it's called.
Well, she's saying yes, but we'll still have the same. Well, I guess they could read what we're saying. All right, how do we enable that? Does anyone know? I have no idea how to enable that.
Typically, it's a setting on like the menu on the remote control. But that's
okay. There it says live transcription has been enabled. At the jail, are you able to read what I'm saying now? Because if we can read, we can keep going with yes. All right, who do we have? Let's do position 19. Let's hope the defendants can read what I am saying. All right, great job. Thank you, Mr. Patrick. You get the Snicker bar today. All right, position 19, Ms. Terry, your case is 22 CR 004569Y, in which you are charged with battery family violence with the offense date of July the 15th. Do you understand your constitutional rights? I believe that was a yes. All right, Ms. Roberts?
She has 6 cycles. Last arrest was September 14th of 2020 for aggravated assault and possession of a firearm or a knife in the commission of or attempt to commit certain felonies out of Fulton County. That is an open case, 20 CP 194078. She also appears to be on probation for DUI out of Spalding County. That disposition was February of this year. 1 day confinement, 12 months probation. And then she appears to have a 2015 battery conviction and nothing further.
Thank you, Ms. Guidry, and try to speak slow enough that we let the transcription catch up with us, if you can.
Yes, I was just going to say I'm going to try to speak slowly. Your Honor, we are recommending a $5,000 surety bond. No further contact with Anthony Taylor, common spelling. A stay away from 1960 Allison Court, Atlanta, the entire apartment complex. 1 day anger awareness. No alcohol, drugs, or weapons, and a one-time escort. Your Honor, this case occurred on yesterday. Officers responded to the area. The defendant and victim were arguing, and she grabbed his neck and scratched him. She then grabbed his penis and testicles and scratched him as well. There was blood coming from the defendant's area, and there was also inside of his underwear. The parties did live together at this time, which was yesterday. We spoke to the victim today. He said that he does want to stay away and no further contact with the victim. He says that he also would want the victim to come and get her belongings. So he would recommend a one-time escort, but he does not want any contact with her at all. And he also wants his car key and door key back so that the defendant cannot get into the home or into his car. He is not on the Zoom today because he does have to work. So again, we are concerned for his safety, given that he did have scratches in those areas. And because of the defendant's history, Your Honor, like the pretrial has stated, she does have an aggravated assault with a deadly weapon that is open from 2020, along with the possession of a knife or firearm during the commission of a felon. So she does have an issue with a risk of reoffending and putting her hands on people. So we would ask for that $5,000 surety bond with a stated recommendation.
All right, thank you. Ms. Wright?
Yes, Your Honor. I did speak with Ms. Marquita Terry. She understands that Your Honor will likely not allow her to return to the location or speak to Mr. Taylor. She has gotten some information from Grady about different shelters that she can go with her 8-year-old daughter. She does have a job. She is an in-home healthcare assistant. She's lived in Rockmart for about 7 years, and she can return to that location as well. Or she could live with her mother, who has her daughter right now. She does not have the means to pay for a bond, and we are asking for a signature bond.
All right, thank you. At this time, defendant's going to receive a $3,000 surety bond. Before I do that, I am going to sound for Mr. Taylor. Mr. Taylor, are you present on this Zoom conference? And do you wish to be heard? All right, hearing none, the $3,000 surety bond will stand. She is to have no further contact with the alleged victim, last name Taylor. She must stay away from 1960 Allison Court. She can return one time with a member of law enforcement to get any items, and she is to have no weapons, drugs, or alcohol as a condition of that surety bond. She will be reset to the SAP calendar on July the 28th, whereby this can be revisited. All right, is there anything further from either the state or the defense?
No, Your Honor.
All right, best of luck to you. Who do we have next?
Position number 20, please.
All right, position 20. All right, are you Jasmine Torres? Your case is 22 CR 004570G, in which you're charged with simple battery with the offense date of July the 15th. Do you understand your constitutional rights?
Yes, Your Honor.
All right, thank you. Ms. Roberts?
11 cycles. Last arrest was from December 10th of 2021 for driving while license suspended or revoked out of Cobb County. There's no disposition listed. She has a 2022 conviction for driving while license suspended or revoked, a 2013 conviction for driving while license suspended or revoked, a 2013 conviction for underage possession of alcohol, and 3 probation violations in 2013. And nothing further.
All right, thank you.
I'm not sure if I said that.
Are you talking about Julia Smith?
No, this is Jasmine Torres.
Oh,
all right, Mr. Patrick?
Yes, Your Honor. The state, this is the cross defendant from your prior position, Ms. Bug.
Position 4, yeah.
The facts remain the same, Judge. However, this defendant placed Ms. Bug in a headlock. The state would show that the facts of this case are more aggravating than the ones from her cross defendant. Therefore, Judge, the state is actually recommending a $3,500 good bond in this case. You've heard the arrest cycles for alcohol-related offenses. Therefore, the state would also recommend no alcohol, drugs, or weapons while out on bond. Furthermore, Judge, because she is not the leaseholder of the residence in question, the state would recommend a complete stay away from 1401 West Paces Ferry Road, Apartment 1312, with the exception of a one-time law enforcement accompanied return to collect any personal belongings. Judge, that is the state's case.
All right, thank you. Ms. McLeod, is this your client?
It is, Your Honor. My client
right.
is 27 years old. She tells me that she is currently unemployed, Your Honor, and has no means to pay for any bond. Your Honor, she tells me that her former roommate was in fact the aggressor in this case, and she was merely defending herself. She understands that she won't be able to live in this location anymore, Your Honor, but she doesn't really have anywhere else to go. So she's going to be challenged as far as housing is concerned, Your Honor. I would like the court to take that into consideration in setting a bond for her.
All right, thank you, Ms. McLeod. At this time, the defendant is going to receive $1,000 surety bond. She must stay away from the address on West Paces Ferry. She can return one time with a member of law enforcement to get any items. She is to have no weapons, drugs, or alcohol as a condition of that surety bond, and she will be reset to the SAP calendar on July the 28th. Is there anything further?
Nothing from the state, Judge.
All right, best of luck to you. Who do we have next? Who do we have next?
Position number 5 in courtroom 1, Mr. Gamble. Courtroom 2.
All right, good afternoon, Mr. Gamble. Your case number is, let's see, scroll up. Your case number is 22CR0045554C, in which you're charged with simple battery, family violence. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
This appears to be his first arrest.
All right, thank you. Mr. Patrick?
Yes, Judge. Your Honor, in this case, the state is actually recommending a $7,500 good bond. The facts of the case are that the defendant and his expectant girlfriend, her name is Lisa Gamble, traditional spelling of both, had been in a verbal argument throughout the day.
I think Lisa Gamble is his mother, Your Honor.
Okay.
As the defendant was walking, I apologize, Lisa Gamble is the mother. The victim in this case is named Kemp, Sweet Kemp, SWEETKEMP. While he was walking past Miss Kemp, or she was walking past him, he pushed her in the back. She advised she was not injured. That's the only reason that the state is recommending a $7,500 good bond on pushing a pregnant woman. Your Honor, the state would recommend that he have no contact with Miss Kemp, barring some order of the Superior Court, pending bond in the event the child is born during the pendency of the case. Furthermore, Judge, no alcohol, drugs, or weapons, and the state's understanding is that the altercation took place at 3045 Seaman Street, Apartment 5. That is his mother's residence, the state believes. As long as Miss Kemp is a resident there also, or to be found at the apartment, he is to not return.
All right, thank you. Ms. McLeod?
Yes, Your Honor. My client is 21 years old. He has been living in the Atlanta area since 2010, and he has strong ties to the community. His mother also lives here in the Metro Atlanta area. My client has never been arrested before. He tells me that he and the mother of the child that he's expecting, they're just having an argument, and he actually touched her on her shoulder. It wasn't that he pushed her. She did not know that they were going to, she did not call the police. Apparently, somebody must have heard them arguing and called the police. She did not know that a warrant was put out against him. This alleged incident happened some time ago, more than 2 months ago. They have continued to live together. They are expecting a child on the 26th of December. And he is very concerned about that. This is his first child and her first child. And they really want to raise their child together. He tells me that he'll be living with his mom. They used to live together. They don't have to live together, but he does want to continue to have contact with her because he is concerned about her well-being and the well-being of the child as she goes into a pregnancy, Your Honor. Since the complaining witness is not opposed to this kind of contact, Your Honor, and given the fact that he's never been arrested before, I would ask the court to consider an order for no violent contact instead of no contact, and they are not living together, Your Honor.
All right, I'm going to sound for Ms. Kemp. Ms. Kemp, if you're present on this Zoom conference, this is your opportunity to be heard. All right, not hearing that Ms. Kemp is present. At this time, the defendant is going to receive a $7,500 signature bond through pretrial services. He is to take the one-day anger awareness course. He is to have no weapons, drugs, or alcohol, and to have no contact at this time with Ms. Kemp. That can be revisited at another date. For now, it'll be a no contact order. And he is to not reside at that address if Ms. Kemp is there, but otherwise he can return to that location. Is there anything further from either party?
Nothing from the state, Judge.
Nothing except, Your Honor, can he have a one-time police escort in case he has belongings still at that address?
Yes, he can. And again, he can return there, Ms. McLeod, if Ms. Kemp is not there. So
thank you.
All right. All right. Who do we have next?
Position. Mr. Ogletree.
Oglesby.
Oglesby, I'm sorry.
What number? I'm sorry, I don't have a printed calendar. Okay, position 14, I see it. All right, Mr. Oglesby, your case number is 22 CR 004564Y, and what you're charged with simple battery family violence. Do you understand your constitutional rights? Do you? Please hurry and say yes or no.
Yes, ma'am.
All right, thank you. Ms. Roberts?
Yes, 48 cycles, 36 out of North Carolina, 12 out of Georgia. Last arrest was from September of 2017 for fugitive from justice. He appears to be on probation for aggravated assault, 13 SC 119314. The disposition was in September of 2013, 9 years probation. Has a robbery conviction out of Georgia from 2011, a burglary and criminal trespass conviction out of Georgia from 2010, one probation violation out of Georgia from 2013. He has a 2019 robbery conviction out of North Carolina, 2016 conviction out of North Carolina for receiving stolen goods, 2016 conviction out of North Carolina for obtaining false pretense, 2015 larceny conviction.
That's good, Ms. Roberts. I think I've got it. Thank you so much. I appreciate that. Ms. Guidry.
Yes, Your Honor. We are recommending a $3,000 surety bond in this case. No further contact with Catrice Lowe, Lowe. Stay away from 711 Center Hill Avenue, Northwest Atlanta. One-day anger awareness and no alcohol, drugs, or weapons. Your Honor, we would tend to prove that today, the defendant and the victim were arguing over a cell phone when officers responded. The victim tried to walk out of her bedroom when the defendant then grabbed her. He pushed her on the bed. He then held her down and then jabbed or poked her in the right eye. She suffered a red and irritated right eye as a result of the defendant causing those issues towards her. So we are concerned for the victim's safety in this issue. We have talked to the victim. She states that she does fear the defendant and that this is not the first time this instance has
Oh, no, I'm perfect. I just had to get it.
Please mute Christopher's iPhone. Christopher's iPhone, please mute. Mr. Jordan, can you mute that? Thank you. All right, go ahead, Ms. Guidry.
Again, as stated, the victim has stated that she does fear the defendant and knows he has done time for other serious violent crimes. So she's concerned for her safety, Your Honor. As pretrial has stated, he has 43 cycles and he's currently on probation for aggravated assault. So we're concerned for the danger of the community as well. So we ask for the $3,000 surety.
Thank you. I'm gonna sound for Ms. Lowe before I go to Ms. Wright. Ms. Lowe, if you are present, this is your opportunity to be heard. All right, Ms. Wright.
Yes, Your Honor. In speaking with Mr. Oglesby, he let me know that Ms. Catrice Lowe does not live there. She has been told many times not to come back. They've previously dated, but they are not together now, nor does Mr. Oglesby want to be with her. She insists on coming back. Mr. Oglesby has his own yard work business. He's lived in Atlanta for over 40 years. And we're asking for a signature bond. Ms. Lowe knows what Mr. Oglesby history is. And Mr. Oglesby believes that she is trying to exploit that in this instance because Mr. Oglesby does not want her to live there with him or have any kind of contact with him at all.
Is that Center Hill address his address is what you're saying, Ms. Wright?
Yes, that's what I'm saying.
And
All
Your
right.
Honor, when we spoke to the victim today, she does state that she still lives there today. So.
All right, at this time, defendant is gonna receive a $2,000 surety bond. He is to have no further contact with the victim, last name Lowe. He can return to the Center Hill address so long as Ms. Lowe is not there. Thus, he can return with one time of a member of law enforcement to ascertain that. If she still resides there, he can collect any personal items, but he will need to stay away from that address. He is to have no weapons, drugs, or alcohol as a condition of this. And again, he will be reset to the SAP calendar on the 28th, whereby this can be revisited.
Thank you, Your Honor.
All right, who do we have next? Best of luck to you, Mr. Oglesby.
Thank you.
Position number 10, Kemp.
All right. All right, good afternoon. Mr. Kemp, your case number is 22 CR 004560J. And what you're charged with, one count of simple battery and one count of simple battery family violence with the offense date of the 15th. Do you understand your constitutional rights? You do understand your rights?
Yes.
All right, thank you. Ms. Roberts.
He has 9 cycles. Last arrest was February of 2021 for criminal trespass and terroristic threats. That does appear to be an open case out of Fulton County, 21 CP 197563. He has an obstruction of a law enforcement officer conviction from 2019, and then a 2012 conviction for burglary, theft by receiving stolen property, and criminal damage to property, and 2 probation violations, 2013 and 2014. And nothing further.
Thank you. Mr. Patrick.
Yes, Your Honor. Pardon me. The state is recommending a $5,000 good bond as to each count. Your Honor, in addition to the pending felony for an act of violence, the other acts of violence, or other acts of obstruction, he also has a charge of abusing public school teachers. So there is a long history of which that wasn't all process, but there is a long history of not behaving as he should. In addition to the monetary value of the bond, the state is recommending that he stay away from 3590 Spring Valley Road, and excuse me, and to have no contact with either Lakeisha, Lakisha, or Starr, Starr. The surname on each of those is Alford. They're a mother-daughter pair. He is in a relationship with Starr Alford. Disagreement started whereby he ended up punching to the ground both the Alfords. Your Honor, he doesn't demonstrate as a good candidate for bond, but for the fact that he is charged with a misdemeanor in this case.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Demetrius Kemp is 30 years old. He has spent in the Atlanta, Georgia area his entire life. He shares a 3-year-old daughter with the complaining witness. We are unopposed to the stay away and the no contact orders. Mr. Kemp completed the 11th grade. He is currently employed at a temp service. He only receives about 8 hours each week. Therefore, he does not have the means to pay much, if anything, toward bond. He does not have anyone that assists with bond. He denies the allegations, and despite my client's history, Your Honor, he's presumed innocent. And what I heard was, an open case. Of course, he's presumed innocent in that case as well. The probation violation is remote, Your Honor, as well as the OLE. Charge in 2019. I am requesting a signature bond, and if Your Honor determines that he is ineligible, I would ask for a bond of no more than $2,000. That would be $1,000 each. We are, again, unopposed to the stay away and the no contact orders, and would ask for third-party transfer.
All right, thank you. I'm gonna sound for either of Miss Alford at this time, either Miss Lakeisha Alford or Miss Star Alford. All right, hearing none at this time, the defendant's gonna receive a $2,500 surety bond, $1,500 for count 1, $1,000 for count 2. He is to stay away from the incident location on Spring Valley Drive, or I believe it was road, and have no further contact with either Lakeisha or Star Alford. He is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either the state or the defense?
Third-party transfer, Your Honor?
And yes, and I will grant the third-party transfer. He can use a third party to arrange, coordinate transport of his child, but otherwise he is to have no contact with either of the alleged victims in this case.
Your Honor, if the state may inquire if there is a parenting plan in place, because if he has no objection to a stay away, if there is no, if he has taken no action to legitimate or establish parenting time, then the state would like to point that out. And
duly noted, Mr. Patrick, but the ruling will stand. The third party transfer is granted. Anything further?
Nothing.
All right. All right. Best of luck to you, sir. Who do we have next?
Position number 15, Parker.
All right. Good afternoon, Mr. Parker. Your case is 22 CR 004565F, in which you're charged with criminal trespass. Do you understand your constitutional rights?
Yes, Your Honor.
All right, Ms. Roberts. Oh, Ms. Roberts.
His first arrest, Judge.
Oh, first arrest. Thank you. All right, Ms. Guidry.
Yes, Your Honor. In this case, on July 12th of this month, in this year, the defendant and the victim were arguing. The defendant then grabbed the victim's phone and threw it to the ground, causing it to crack. And the repairs via the victim, Julia Smith, are about $150. The parties do have children together and they live together. We are recommending a $2,000 signature bond, given that this is the defendant's first arrest. No further contact with Julia Smith. A stay away from 1106 Preckness Drive in Alpharetta, and no alcohol, drugs, or weapons. We are asking for the no further contact because we couldn't speak to her due to her also being arrested this morning. But a notice of dismissal was implemented in her case.
All right, thank you. Ms. Wright, I'm inclined to agree with the state and grant the signature bond and no further contact. Does the defense have any objection to that?
Your Honor, I would ask that you consider a no further violent contact, because I think they do have children together. Otherwise, I would ask for a third party transfer allowance.
All right, I am going to issue the no further contact in light of the fact that the two are co-defendants and I cannot hear from the cross defendant at this time. So it will be no further contact, but he can arrange the transport of the child with a third party, and he is to stay away from that address during the pendency of this bond.
And Your Honor, if I may, what is the bond amount?
It'll be a $3,000 signature bond through the jail.
Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Next is position number 11. I don't know how to pronounce the last name.
Position 11. All right, please pronounce your last name for me very quickly.
Kiriakou.
Mr. Kiriakou, your case is 22 CR 004561F, in which you're charged with several offenses, including speeding, reckless driving, driving without an expired license, willful obstruction of law enforcement officer, and possession of marijuana less than an ounce. Do you understand your constitutional rights? Yes? All right, thank you. Mr. Patrick?
Yes, Your Honor. The state is recommending a $2,500 good bond on each count. Despite the fact that these are traffic offenses and this is his first cycle, the facts of this case are pretty egregious, Judge. He was clocked doing 103 miles an hour in a 65 zone on Georgia 400. Officers of the Alpharetta Police Department initiated a traffic stop. Following that traffic stop, they asked him to exit the vehicle. He verbally replied no, and then he moved his hand towards the gear shift knob on the center stack to, though he did not attempt to drive away, he certainly made actions towards that end. Your Honor, he was removed from the vehicle by officers, and at that point he kept resisting. It was not until they informed him they would deploy their tasers that he began to comply. Paraphernalia related to the distribution of marijuana was also found in his vehicle, though no actual marijuana was packaged as such, and it was a misdemeanor amount of the actual illegal substance. Your Honor, this case poses a great public safety risk based, if nothing else, on the speed. He was doing, within 10 miles an hour or more, a little more than that, but he was doing within 20 miles an hour of twice the speed limit, Judge. And there were other vehicles on the roadway, not just him and the officer. The state believes that a $2,500 good bond per count is actually a generous offer in this case, Judge.
All right, thank you. Ms. Gant.
Thank you, Your Honor. Mr. Kiriakou is 21 years old. He has been in the Atlanta, Georgia area for 1 year. He has family here, including an aunt and cousins. Mr. Kiriakou completed high school. He also has 2.5 years of college where he studied business management. He is currently employed as a client advisor for MCM Worldwide. He has been in that position for the past 2 months, so he is on probation, and he states that he has missed work already, so he may have lost that job, Your Honor. I am requesting a signature bond. This is his first arrest, and we did not hear about any prior driving and/or traffic offenses. He is presumed innocent. These are allegations at this point, Your Honor. Therefore, I'm requesting a signature bond. Thank you, Your Honor.
All right, at this time, the defendant is going to receive a $3,000 surety bond, broken down $500 each charge. And he is to have no weapons, drugs, or alcohol as a condition of this. He is not to drive unless he has an official license issued by the Georgia DDS at this time. Is there anything further from either the state or the defense?
Nothing from the state, Judge.
Nothing from the defense, Your Honor. Thank you.
All right, best of luck to you, sir. Who do we have next?
Position number 22, Wilson.
All right. All right, good afternoon, Mr. Wilson. Your case number is 22 CR 004557G, in which you're charged with 1 count of battery family violence with the offense date of January 1st of 2022. Do you understand your constitutional rights?
Yes.
All right, Ms. Roberts.
We're on Wilson.
Yes, Wilson.
Wilson. 4 cycles. Last arrest was February 23rd of 2020 for willful obstruction of law enforcement officer, criminal damage to property, entering auto, and possession of tools for the commission of a crime. That case appears to be open. That case number is 22 SC 182691. He also appears to have an open case for DUI, failure to maintain or improper lane change, following too closely, and reckless driving, 22 CR 001877G. He also appears to be on probation out of California for vandalism. The disposition date was August of 2020. 36 months probation. And he was on the felony calendar this morning for entering auto and possession of a firearm during the commission of a felony. And that bond was $104,000.
All right, thank you. Ms. Guidry?
Yes, Your Honor. We're asking for a $5,000 surety bond. No further contact with Bria, Bria Harris, common spelling. A stay away from 1185 Collier Road Northwest, Atlanta.
Hear me? Ms. Gant?
Please,
Hello, hello?
please stop speaking Christopher's iPhone. Go ahead, Ms. Guidry.
A stay away from 1185 Collier Road Northwest, Atlanta, the entire complex, 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, this incident occurred on February 1st of this year. We would tend to prove that the defendant and the victim were arguing because the defendant saw something in the victim's phone that made him upset. The victim went to sleep in her bedroom when she was awakened by the defendant pouring water on her. The defendant then threw an object from the room at her and started hitting her repeatedly while saying, "I should hit you like a dude." The defendant continued to hit the victim as she tried to call her mother and 911 for help. The victim did suffer a bruise to her right eye. It should also be noted that the victim and the defendant have lived together since August of 2021. We did speak to the victim in this case, and she stated that she and the defendant are no longer together and do not live together. However, we did not get that address, so we would ask for that stay away, given that we didn't get the address from her. We are also concerned that the defendant was arrested just yesterday for those felony charges, and he did receive the $104,000 bond.
All right, thank you. I'm going to sound for the alleged victim, Ms. Harris. Ms. Harris, if you're present on this Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none, Ms. McLeod.
Yes, Your Honor. My client is 25 years old. He is originally from California, but has been living in the Metro Atlanta area for more than 6 years. He tells me that he recently graduated from Clark Atlanta University with a bachelor's degree in business administration. He's currently trying to set up his own barbershop as a business. He actually works as a barber right now, and that is his plan. He denies the allegations made by the complaining witness, Your Honor. He said they actually were having an argument, but that he did not hit her. This incident happened some time ago, Your Honor. The 1st of February, I believe, was the date stated. They have not been living together since then. They are no longer in a relationship. He is not a danger in any way to this young lady, Your Honor. In this case, I think a signature bond. I'm sorry, Your Honor, I seem to be having some problems with my internet. I hope the court can hear me.
Yes.
Yes, in this case, I think a signature bond would be appropriate, Your Honor, because it's a significant time ago since this incident occurred. The parties are not in contact with each other. The prosecutor stated that the young lady has affirmed that they're no longer in a relationship. They're not contacting each other. It seems that he has a bond for something else, which is quite significant, and he really is in no position to come up with money for this bond. So if he doesn't get a signature bond, he'll probably be just sitting in the jail on this particular charge, Your Honor. So given all of that, I would ask the court to consider giving him a signature bond.
All right, at this time, defendant is going to receive a $2,500 surety bond. He is to have no contact with the alleged victim, last name Harris, and he is to stay away from that stay away address unless if the victim resides there. He can return one time with a member of law enforcement to ascertain that. If the victim is not there, he can return to that location. He is to have no weapons, drugs, or alcohol as a condition of that bond. Anything further from either party?
Nothing further.
All right. All right, best of luck to you, sir. Who do we have next?
Position 16, Reeves.
All right, good afternoon, Mr. Reeves. Your case is 22 CR 004566C, in which you're charged with criminal trespass and obstruction. Do you understand your constitutional rights?
Yes, Your Honor.
All right, Ms. Roberts.
I'm I'm only showing one prior arrest from April of this year for battery. That is an open case, 22 CR 002-372C.
All right, thank you. Ms. Guidry?
Yes, Your Honor. We are recommending hold on, let me find the right paperwork because my laptop is acting crazy. Okay. The defendant currently has a $2,000 surety bond, $1,000 surety on each count. We are recommending $1,000 surety bond for each count, a stay away from MARTA if he has active suspensions and no alcohol, drugs, or weapons. Your Honor, officers were patrolling the Midtown MARTA when they observed the defendant sitting at the outside portion of the MARTA station. When asked why he was there, he stated that he was waiting on his girlfriend. The defendant continued to stay at the station for over an hour before he was given multiple commands to leave. The defendant then refused, and as officers attempted to handcuff him, he pulled away multiple times. Officers were finally able to handcuff him with the assistance of a citizen who was there on the scene. He does have an open battery charge from April 2022, so we're concerned that he does have a history with the community, so we're concerned.
All right, thank you, Ms. Wright.
Yes, Your Honor. This case is interesting because all that Mr. Reeves was doing was just sitting and waiting for his girlfriend to arrive. I understand that the officers told him to leave. He was waiting. He didn't want to. He wasn't committing a violence to anyone. He just didn't want to be arrested for doing literally nothing. We are asking for a signature bond for Mr. Reeves. He does not have the means to make a bond. He's 18 years old. He works at a warehouse through a temp service, and he's lived in Atlanta all his life.
All right, thank you. At this time, defendant is going to receive a $5,000 signature bond through the jail, $2,500 each charge. He is to stay away from MARTA as a condition of this signature bond and have no weapons, drugs, or alcohol. Is there anything further?
That's all, Your Honor. Thank you.
All right, best of luck to you, Mr. Reeves. Who do we have next?
Position 17, Sims.
All right, and I believe position 17 only has one charge, is the information I received in the chat. Ms. Sims, your case number is 22 CR 00456-7F, and you are charged with obstruction of a law enforcement officer. Do you understand your constitutional rights?
No.
I'm sorry, what?
Yes,
Do you
ma'am.
understand? Thank you, Ms. Roberts.
Yes. 6 cycles. Last arrest was January 17th of this year for theft by possession of stolen mail, printing, executing, negotiating checks, drafts, etc. Possession of a firearm or knife during the commission of or attempt to commit certain felonies, selling marijuana, and financial identity fraud. That case appears to be open, 22 CP 205883, and 1 conviction from 2019 for driving without a valid license, and nothing further.
Thank you. Ms. Guidry.
Yes, Your Honor, this incident occurred yesterday. Officers responded to 120 Piedmont Avenue in Atlanta. They were investigating a drug dealer involving another individual who's in the vehicle with the defendant. While trying to conduct that investigation, the passengers, including Mr. Sims, locked the door and refused to unlock it. They eventually unlocked the door and Mr. Sims was arrested. He was also charged with driving without a valid license, well, suspended license, however, that was NOD. Your Honor, given the very minimum facts of this case, we are asking for a $1,000 signature bond and no alcohol, drugs, or weapons.
Ms. Wright, any objection to that? I'm inclined to agree with Ms. Guidry.
No objection, Your Honor.
All right, at this time, defendant will receive a $1,000 signature bond through the jail. He is to have no alcohol, drugs, or weapons as a condition of that signature bond. All right, I believe that will resolve Mr. Sims' case. Best of luck to you, sir. Who do we have next?
Position number 18, Taylor.
All right, good afternoon, Mr. Taylor. Let me get your case number. Your case number is 22 CR 00456-8J, in which you're charged with simple battery. Do you understand your constitutional rights?
Yes, ma'am.
All right. Ms. Roberts?
I'm showing 4 cycles, 3 out of Alabama, 1 out of Georgia. The last arrest was in 2001 for battery, aggravated assault, and simple battery out of the cab. That was a conviction, just for the simple battery and battery. And then
All right.
1984, Alabama theft.
Okay, we won't deal with that one, but I think that's sufficient. Thank you, Ms. Roberts. Ms. Guidry.
Yes, Your Honor, we're recommending a $2,000 surety bond, no further contact with Michael Mumphrey, a stay away from Greyhound Station, 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, this incident occurred yesterday at 232 Forsyth Street, Southwest Atlanta. The defendant started arguing with the victim, Mr. Michael Mumphrey, who was a Greyhound bus driver, because he was not on time for the defendant to get on the bus. The defendant refused to listen to Mr. Michael Mumphrey, and he continued to argue with Mr. Michael Mumphrey. After getting off of the bus, the defendant then followed Mr. Mumphrey outside of the bus area. He continued to harass him, and then he punched him in the neck with a closed fist. Your Honor, given that the defendant punched the bus driver for no reason at all, simply because the bus driver was late, we're concerned for the safety of the community.
All right, I'm gonna sound, is Mr. Mumphrey present? Mr. Mumphrey, are you present on the Zoom conference? Hearing none. Ms. Wright.
Your Honor, the story that the state tells is really awful, except that that's not the experience that Mr. Taylor had at all. Mr. Taylor doesn't live here. He lives in Alabama. He's lived in Alabama a long time, and he's disabled. However, he's trying to get back to work. He is a truck driver. And he was brought by the company to Atlanta to do some testing to see whether he would be able to go back to driving trucks. He was on his way back to Alabama, and this wasn't just him. There was a lot of folks that were taken from not just Alabama, but from different states to Atlanta to test for this truck driving company. There was a lot of chaos. A lot of folks were having a really hard time figuring out which buses they were supposed to get on and get off. This particular person, the complaining witness, was quite rude, yelling at everyone, screaming at everyone, being quite aggressive to everyone. Mr. Taylor, who is 58 years old, went up to him and was trying to just sort himself out and sort out some of the other folks that were around him. And this man starts pointing at him, getting in his face, getting quite close to his face. And in an attempt to get this man off of his face, he pushes him away with his hand. He's trying to get this man off of him. It wasn't that this poor bus driver was just doing his job and Mr. Taylor just ran up to him and out of rage punched him in the neck. Absolutely not. This man was quite aggressive, not just to my client, but to everyone in that area. The police report doesn't say whether they took witness statements or not. I'm sure the state feels strongly that they could prove their case, and we are more than comfortable saying that we highly doubt that. And we will be fighting all of those charges. We are asking for a signature bond for Mr. Taylor. He is not in the state. He has no reason to be a danger to this community. He is not part of this community. He's got a phone number that he's given pre-trial and an address. There's no reason to believe that Mr. Taylor would not be good on his word and return to Atlanta when the time comes.
At this time, defendant's going to receive a $1,500 surety bond. He is to have no further contact with the alleged victim, last name Mumphrey. I am not going to issue the stay away at this time, hearing that he may need to use the bus to leave the jurisdiction, but he is to have no further contact with that driver. Is there anything further from either the state or the defense?
No, Your Honor.
Further.
All right, best of luck to you, sir. Who do we have next?
Position number 23, Water.
All right, and I believe that there was an announcement for 23 in the chat. Let me go back and look what it was.
Oh, it was an added charge. It's two.
Oh, it's an additional charge. Okay, Mr. Woodard, your case is How you doing? Good
I'm
afternoon. Your case is 22 CR 004572E, in which you're charged with pointing or aiming a gun or a pistol. And then you have another one, 22. Okay, I think you have two counts of that, pointing or aiming a gun or a pistol, with the offense date of February the 11th. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
He only has one cycle on his GCSE, but it's for a probation violation out of Riverdale. And the underlying charge was marijuana less than an ounce, but that cycle isn't showing up on the GCSE.
All right, thank you. Ms. Guidry.
Yes, Your Honor. When the defendant was arrested, he only had one count of pointing or aiming a gun or pistol at another. He currently has a bond set on that charge of $25,000. We are recommending $12,500 surety on each count now that he has two counts. No further contact with Tyra Cross, that's Tyra, or Tiana Cross, common spelling. A stay away from 369 McDaniel Street, Southwest Atlanta, the entire complex. 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, this incident occurred on February 11th of 2022. We would tend to prove that the defendant and Tiana Cross were arguing. She called her mother, Tyra Cross, to come and de-escalate the situation. When she got there, she and the defendant started arguing, Ms. Tyra, and the defendant pulled out a pistol out of his pocket and pointed it at her and Tiana. Once the pistol was pointed, the argument concluded and Ms. Tyra and Tiana walked away and called police. Your Honor, we're concerned that the defendant feels the need to pull out a gun simply because of an argument, Your Honor, on two females for no reason. As you are aware of, the state is gravely concerned with gun cases, and this is a gun case. The defendant was not on the scene when police were there. We were unable to talk to the victims, given that the number that the police placed in the police report was the same number for both victims. We would also like to state that the second charge was added due to the incident report. The warrant did not have both parties listed, but once we got the incident report, it was noted that he pointed the gun at both parties. So we are concerned that he is pulling out guns on people, and we are gravely concerned with gun cases. And this is a grave case. And had the gun gone off, Your Honor, we would be here for a different situation. So we are asking for a $12,500 surety on each count, given this incident. And we are in the process of possibly transferring this case to the DA's office on Monday for aggravated assault, given that he did point a weapon at two females. And now that we do have the incident report, so we can move forward.
Thank you, Ms. Guidry. Ms. Wright.
Your Honor, I'd like to point out that the affidavit for arrest indicates that my client was pointing the gun at the ground in front of the victims, not directly at them. It wasn't until later that changed. Mr. Woodard works security for Mercedes-Benz Stadium. He's lived in Atlanta his whole life. And with Miss Tiana, he's got a newborn on the way that's due in January. I have not had the opportunity to speak with either person. I'm not sure what their feelings are, but I do know that Mr. Woodard does want to have contact with his newborn when the time comes in January.
All right. I'm going to sound for either Ms. Cross at this time. All right, hearing none, defendant is going to receive a $7,000 surety bond, $3,500 on each charge, and he is to have no further contact with either Tyra or Tiana Cross, and he is to stay away from that incident location on McDaniels Drive. He is to have no weapons, including the subject weapon, drugs, or alcohol as a condition of that surety bond. He'll be reset to the SAP calendar on July the 28th.
Thank you.
Is there anything further?
Nothing further.
All right, best of luck to you, sir. Who do we have next?
Stand by.
Last petition in courtroom 3, Eric Jackson.
I'm sorry, both of y'all were speaking at once. I'm sorry, who do we have?
Eric Jackson, the last position on the calendar.
I'm sorry, give me a number. I don't have a printed calendar. It was position 3?
Position 9, Judge.
Position 9. Thank you all for this group effort. All right, Mr. Jackson, your case number is 22 CR 00455 9Y, in which you're charged with theft by taking. Do you understand your constitutional rights?
Yes, ma'am.
All right, thank you. Ms. Roberts?
Yes, Judge. I'm showing 2 cycles. Last arrest February 5th of this year for simple assault, family violence. That case is open, 22 MAGC 00626. And then he has one other open case for theft by taking, 22 SC 180848, and nothing further.
All right, thank you. Mr. Patrick?
Yes, Your Honor. As you heard, he has an open case out of the city of Atlanta for theft by taking. The facts, the state's recommendation in this case is that he post a $1,500 good bond. That's based on the fact that he's got a prior or an open theft by taking. The facts of this case are, Judge, that he asked to borrow the telephone belonging to Tyreek, Tyriek, Henry, common spelling. The two have been acquainted for 10 years or more. Mr. Henry handed him his iPhone 12 Pro valued at $999. The defendant just took off with it. The state would point out that he is arrested on average about every 6 months since November. So state has some concern there. State would recommend that he have no contact with Mr. Henry, that he possess no weapons while on bond, because he also has a simple assault family violence that is pending from the city of Atlanta. So no alcohol, drugs, or weapons, but state already said that. Your Honor, that is the state's case.
Thank you, Ms. Patrick. Understood. Ms. McLeod?
Yes, Your Honor. My client is 19 years old. He lives in Atlanta. He tells me that he lives with his mom and his grandmother. He denies the allegations of the prosecution's case, Your Honor. He says that he did not take off with the phone. He just borrowed it because he didn't have a phone at the time. And, he was using it. That person is a friend of his, Your Honor, and he did not intend to permanently deprive him of this phone. Your Honor, he has an open case, but he is presumed innocent in that case. He's just 19 years old. He's not working. I would ask the court to consider giving him a signature bond, given the nature of the offense that is alleged, Your Honor, and his situation. He's not working, and he is unable to live on his own. Thank you, Your Honor.
All right, at this time, the defendant is going to receive a $10,000 signature bond through the jail. He is to have no further contact with the alleged victim, last name Henry, and to have no weapons, drugs, or alcohol as a condition of that signature bond. Is there anything further from either party?
And nothing further, Your Honor.
Nothing from the state.
Does that complete our calendar today?
Yes, Judge, the state's business before you is complete. May the state be dismissed.
Does the state not want to hear the calendar reconciliation?
Oh, I forgot we did that. I'm sorry.
I think that might be helpful. Mr. Jordan, if you would very quickly review the calendar, and I would like to commend everyone, despite all of our complications today, we still managed to complete quite an extensive calendar in less than 2 hours. I believe the jail can be excused. Have a great afternoon there at courtroom 2 and 3, unless there's anything further from the court, unless you all would like to hear the calendar reconciliation.
Judge, how much was Mr. Jackson's bond?
Oh, that's who I just did. That he received a $10,000 signature bond through the jail.
Okay, thank you.
All right, courtroom 2 and 3 can be excused. Mr.
Thank
Jordan,
you.
please.
Your Honor, I had a client who apparently I spoke to her and everything, but she wasn't on the calendar. I just wanted
Miss
to
Smith.
Miss Smith.
Her case was NOD.
Yeah, it was an NOD.
Okay, thank you.
All right, Mr. Jordan, if you would review for us.
Position 1 is a $2,500 surety bond, reset SAP. Position 2 is reset to Monday's SCA calendar to get a Spanish interpreter. Position 3 is a $12,000 split bond, reset SAP.
What was the
Position
number?
4.
I'm sorry.
It was 10,000 on charge 1, sign on bond jail. and 2,000 on charge 2.
Thank you.
Sure. Position 3 is a $3,000 sign-on bond pretrial. Position 5 is a $7,500 sign-on bond pretrial. Position 6 is a $3,000 sign-on bond pretrial. That's $1,500 per charge. Position 7 is a $3,000 sign-on bond pretrial. Position 8 is a $4,000 surety bond. That's $2,000 on each charge. Reset SAP. Position 9 is a $10,000 sign-on bond jail. Position 10 is a $2,500 surety bond, $1,500 on charge 1 and $1,000 on charge 2. Reset SAP. Position 11 is a $3,000 surety bond. Reset SAP, that's $500 per charge. Position 12 is a $5,000 surety bond. Reset SAP. Position 13 is a $4,000 surety bond. Reset SAP. Position 14 is a $2,000 surety. Reset SAP. Position 15 is a $3,000 sign-on bond jail. Position 16 is a $5,000 sign-on bond jail. That's $2,500 per charge. Position 17 is a $1,000 sign-on bond jail. Position 18 is a $1,500 surety bond. Reset SAP. Position 19 is a $3,000 surety bond. Reset SAP. Position 20 is a $1,000 surety bond. Reset SAP. Position 21 is a $2,000 sign-on bond jail. That's $1,000 per charge. Position 22 is a $2,500 surety bond. Reset SAP. And position 23 is a $7,000 surety bond, $3,500 per charge.
Any comments, changes, questions, or corrections?
No, Judge.
Hearing none, we will be in recess until Monday's SCA calendar, at which time Judge Morrow will be residing. Everyone have a great afternoon, and remember that Mr. Patrick gets our Snicker bar when I'm back in the courthouse.